Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
Is the next church on February 28, 2020? 7:44 p.m. How, does the FBI find people? And people is misspelled P-O-O-P-L-E.
Because he's the guy.
Did the defendant find out how the FBI finds people in this case? Oh, she found out.
I object.
Welcome back to the Court of Public Opinion. I am the Recovery Addict. Oh my goodness. Crazy lunch. News breaking all over the place. We are buckled in for what might be just a nutso afternoon. It's going to be crazy. There's a lawsuit. Yes. Welcome everyone. Welcome. Please come in. Have a seat. Thanks for all those who already hit the like button. 321 of you, 321, have already hit the like button. Thank you for just getting that out of the way. Oh my goodness. My wife had to run an errand, and she looked at the computer or the iPad to get the directions on driving. And she's like, "Why is it telling me there's a winter storm warning? It's like 65 degrees outside." It's like, why is there a winter storm warning on my driving instructions? Yes, we are waiting all sorts of storms today, both in the weather and in the world of true crime. Anyway, we're going to kick things off. First of all, Kim, we're going to count on you. You are first in chat today. Congratulations. The internet is all yours. We have snow and ice coming our way. Keep the internet up through all of it if you can. That would be great, Kim. I would appreciate that. Thank you very much. Diana Meyer, welcome to the jury. Diana, thank you as well. Thanks for your support. This wouldn't be possible without wonderful people like yourself. Thank you. We have a couple other things. Patricia, thank you for the super chat as well. Patricia, very generous, longtime supporter as well. All right, we have, please record the spice that happened that I sent to Pod Chat. I need more recorders is what I need.
You look good.
Where are we at? Okay, forget Karen Reed and the fact that the judge just put a hold on the whole proceedings because of something she heard coming from the feds. Let's forget that and pretend that didn't happen during lunch as well. Okay, so that's going to be off over here. We have in this trial right here, defense is about to start and has blown the case into Neverland as far as what's about to happen. We have no clue. Neverland's probably a bad example. That's Peter Pan, right? Or Michael Jackson. Depends on how you view that reference. Oh no, I didn't mean that one. We're expecting the defense to start with what can only be described as a defense of others defense, which is limited in what they can bring in. I don't think they're going to allow the daughter, the victim, to testify in what they want to bring in, but how close they get to that line and what they're allowed in, we may be approaching new territory in this case. So that being said, here's your warning. There might be some content in what comes out in testimony today that is pretty rough, and we're sort of playing it by ear. Obviously, the judge knows that some is coming, but we don't know how much. They've been fighting over this all morning in chambers and out, but outside the presence of the jury, which means outside our presence, and we're just waiting to see how this all shakes down. But the opening statement from the defense was basically, "I am so glad to be here. It's now our turn. The state sat down. They had their turn. I could have fought them on all sorts of issues, which they did, which is funny because he's doing that. So I could have fought the DNA, which they did, and all that. But instead, Zach has been waiting for 3 years to get up here and tell you his story, and he's going to tell you that he did it and why, and that the jury must have just about fallen out of their seats. This whole time, this trial has been, we're going to prove to you what happened, and we're going to put the pieces together so you can see that it was the defendant that did this. And when it's the defense turn, he gets up and he's like, it was me. Right here, this guy, I'm the guy. And let me tell you why, which is bizarre. It was crazy. It's I still can't get my jaw off the floor. Right. It's wild. So we're going to watch it starts in about 6 minutes roughly. We're expecting the video to start. We realize that social media has a half-hour jump on us. That's by court order. Social media gets a half-hour head start before the tape rolls. I don't know why. I think judges don't understand necessarily technology very well. Why media is restricted to only see what the jury sees instead of what the public can see. Wouldn't it make more sense to allow the media to see whatever anyone who walks into court is allowed to observe? That's just me, but that's it. What happened to Karen Reed? I don't know, something on the Fed side that caused the judge to say, hold up, I have big concerns. I have to mute also. Please give descriptive facial expressions. Like that. Somebody's going to clip that. Thanks, Phil. Those are my facial expressions. I'll try to use them appropriately. Tape is 1/2 hour behind, but Twitter is a real time though. Yes. So if you need to have the latest and greatest, let us know. That's the sport. Yeah, I don't know much about what I've shared about Karen Reed. Brandy Churchwell is covering that one live. There's probably a bunch of other creators that are covering that one. They might be the best bet to get the latest if you want that. I'm not going to be your best source on that one. That's not a trial I've been following so far. Lots of interpretive dance. Yes, I shall do it. Australian style interpretive dance is what we're going to do. All right. Let's see. Katrina, thanks for the kind words. Emily D. Baker's on Karen Reed, lawyer you know as well. Those are great options. Both fantastic pillars of LawTube.
I was kicked back.
I'm honored to be LawTube adjacent to them. All right. Yeah. Wogger, I'm not there for the drama. That's the one thing that's pushed me away from Karen Reed. The drama happening outside of court is to me a distraction from the legal battle that's happening inside of court, which I think is interesting and has lots of twists and turns. But I'd like to keep it just within court and within those battles. Okay. Let's see. In a moment, let's get ready let's go to court, shall we? In case something happens. There we go. All right, we're ready for court to begin. During the lunch break also, while all this was happening, I'm getting texted from about a bajillion people. The shower pan for my bathroom remodel showed up. R&L freight truckers, I forget who it was. Didn't knock on the door, didn't call, as they're supposed to do both. And I see Walmart. From the kitchen, I see him out on the street. I'm like, oh, the truck's here. I'm cool. That's cool. So I go out on the back step and I'm waiting for him to get out. And he looks over at me. I'm like, hey, right here. This is the spot. And he's like, okay. And he nods and he drives off. I'm like, I did the here. I didn't do the, that one. He drives off. And then I see that he's already dropped it off in my driveway. And somebody somewhere along the line, when loading it, unloading, whatever, took that forklift and drove that forklift right through the shower pan. It's like skewered. Okay, it is destroyed. You don't. So Lisa says, "Hey, I work for R&L." Well, he drove off. Your driver drove off, and you don't have to be like an expert plumber like myself to know that this is completely ruined. Oh, witness chair. We're getting some motion. It's completely ruined, but it's now on my driveway, and calling the manufacturer,
in front of the Walmart.
I called and got like the ring around, and finally got somebody's like, okay, let me transfer you to the person, and they didn't answer. She picked up again. She's like, okay, I'm going to transfer you to the voicemail. Leave a message. Transferred to voicemail. The company doesn't have voicemail. It literally says, oh, they didn't pick up. Call again later, and hung up on me. So I'm trying to fight that. So, I've got pictures already. I've got pictures. There's like just, it's shattered. The shower pan's shattered. And I'm pretty sure the shower pan is supposed to be like waterproof, like not allow water to go through. So.
Are we going to address subject matter jurisdiction?
That's why he took off. I work with freight. You should have had the opportunity to note damage. I agree. And now it's still sitting on my driveway, photographed, banded up. So, called the delivery service. Might have to do that. Okay. Josh, I'm not sure if I can record what you sent me. Amber's already posted facial expressions on the. She's already clipped it and posted it on Twitter. Okay.
I'm not a camel.
All right. It is straight up. It is straight up 2 o'clock, which means half an hour ago court should have begun. We're now just waiting for any delay that might have happened when the court came back from lunch. What's a shower pan?
Thank you, sir. You're my new best friend.
It's the bottom part of the shower that's already pre-built. It has like a foam insert and the drain hole and all the bottom. We're not tiling. We're using like preformed plastic over styrofoam, I think it is, and it's ridiculously expensive. But I can't tile, so this is the option. At least I follow instructions as given. Reverse on any debit credit card that will get their attention. I like to try to not go that route. Call R&L customer service. I'll take care of it. Okay. I might have to do that. Okay, I'll call them, but I'm not going to have it I'm not going to do it live. Let's see. Laurie says, I've enjoyed listening to Josh Ritter a lot. Thanks for introducing us to him. He does updates on all sorts of trials. If you can't watch so many trials, I love his content. He's really good. Josh is phenomenal. Love what he's doing. Readers. I said it. Call them a shower tray in the UK. That's what it is. We call it a shower pan here. I don't know why. Meltdown. Yell, I need my bathroom, and then scream, that will get you replacement fast. That's how it started, Laurie, for me. That's how it started. Or Mrs. R.A. She's like, this has to get done this year. What's Josh's channel, please? Josh's channel is Courtroom Confidential on YouTube. And he was awesome enough to invite me on for an interview. I think it was last week. And it was really, really good. Loved it. Hope to do some more with him. Virginia, this is true, but we only know that after the fact. All right. There's the link. Thank you, Amber, for posting that. There's Josh's channel. All right. Use the goat on your call. Yeah, I'm calling about your delivery. Yeah. I don't know what was probably happened in shipping. I can't imagine the manufacturer sent it out this way, but because I don't think the driver would have taken it. Okay. All right, we're ready, Judge. If you could go ahead and bring the jury in. I don't think we can wait any longer. The best the state has shown is his DNA is under her fingernails, right? So him admitting is pretty big. Well, that DNA is that's a game changer. I mean, that's a smoking gun. But yes, him admitting is really big because the jury this whole time has been, mentally taking notes because the judge won't let them actually write notes. Mentally taking notes about if they think that the state has proved that Josh has done it, and Josh is going to get up and say, "Yep, it was me." So I think think they should have done this sooner, because I mean, really, the waste of time the state put on all this stuff, and now we're in the rebuttal. Obviously, we're going to have a big rebuttal phase of trial if the state thinks that they can prove, that it wasn't in defense of another. But Sherry Smith, welcome to the gallery. Oh, okay. I heard the goat. I love the goat. Okay, we have been sitting here all day. I think any moment now going to be starting. How many stab wounds? 35-ish. Cut and stab, 35 total. Jennifer Cockfield gifted a membership. Thank you very much, Jennifer, for your generosity. Cozy Coding. I learned that the scrambled messages from WhatsApp were used for the search index. All capitalization, punctuation, and duplicates are removed. Oh, duplicates are removed. That's fascinating. So each word only appears once. I wonder if the defendant will own up to what they said on the, decode them for us. No, this is what he said. I wonder if he'll do that. Okay. All right. Let me see. All right. Is he going to take the stand? Yes. The defendant is going to take the stand. Think Beethoven's concerto in stab wounds. Okay. Zach, not Josh. Josh is from Courtroom Confidential. Zach is the defendant. Did I say Josh? Yeah, don't throw Josh under the bus. If I did, I apologize. Josh is the good guy. Zach is the defendant, who may be the good guy. Here we go. Court starting.
Hey, welcome back. Again, I ask, has anyone done any research or anything concerning this from any media outlet? No one note for the record. Jury in the case. Absolutely not. Vince?
May it please the court, the defense would call Investigator Dan Petal, please.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Please state your name for the record.
Daniel Bevel.
Investigator Bevel, you were called in the state's case in chief. Do you remember that?
Yes, sir.
And my understanding is it correct that you began working for the sheriff's office, Greenville County Sheriff's Office, roughly in 2012? Is that correct?
That's correct.
And you've got a bachelor's degree from Troy University. Is that correct?
Yes, sir.
You testified about this previously, but briefly tell this jury what units you have served in the sheriff's office.
I started in patrol from 2012 to 2017. That's your standard uniform patrol deputies answering 911 calls, any kind of call for service. After that, I went to specialized investigations from 2017 on to, and there I went to the Crimes Against Children unit from 2017 to 2019. That's any kind of child abuse, child neglect, child sex crimes. Then after that, 2019 to 2023, I went to the Internet Crimes Against Children unit. That's any kind of child exploitation.
Investigator Bevel, you talked about your time in the Crimes Against Children unit. when you're in a specific unit within the sheriff's office, do you receive specialized training associated with that type of unit?
Yes, sir.
Right. And so, when you were on the road in uniform patrol, did you receive specialized training related to that?
Yes, sir.
And when you were in the unit of the crimes against children, did you receive specialized training in that discipline?
Yes, sir.
And let me show you Defense Exhibit 65. Just take a look at this for identification only.
Dan, I answered. I even held up the box showing what brand it was.
Yes, sir.
Investigator Bevel, for example, that is the report you drafted for the purpose of the harassment investigation. Is that correct?
It is, sir.
And so this is of the kind of report you would draft depending on what investigation you were conducting or what task you were performing with the sheriff's office.
That's correct.
As an investigator, are you familiar with a phrase called the lead investigator?
Yes, sir.
And ultimately, the lead investigator is just that, the investigator on a case who is ultimately responsible for the investigation. Is that correct?
Yes, sir.
And in this case, Investigator Sparkman would be deemed or likely be the lead investigator. Is that correct?
That's correct.
Were you also the lead investigator in another case in connection with this case? Let me ask it a different way.
Yeah, be careful here.
On October the 19th, 2021, did you become the lead investigator in another case?
Objection.
State your objection. Objection. This is going to fall under your previous ruling. Okay. I will sustain the objection.
Not allowed in.
Okay. Your Honor, due to Your Honor's previous order with the restriction, I'm going to move on, and I'm going to move on.
Yeah?
Investigator Bevel, you testified, as you said, in the state's case in chief, and that was just last week, wasn't it?
Yes, sir.
And I would imagine you're still familiar with your testimony in the state's case in chief.
Yes, sir.
And I want to talk to you about that testimony. And specifically, I want to refer to a specific portion of it. Do you remember during your direct examination, you testified about mailers and the contents of mailers that you had been provided in the early summer and through the summer of 2021. Do you remember that testimony?
I believe so. Are you referring to the mailers as what I was given by Postman Parcell?
Yes.
Yes, sir. Yes, sir.
And you testified that those mailers had nude photographs of Christina Parcell in those mailers. Is that correct? Remember that?
Yes, sir.
And I've got a transcript. I want to ask you specifically about this exchange. Do you remember being asked by Mr. Wilkins, when you first got these photos, let me back up. Do you remember testifying about the fact there was a website listed on the photographs? Do you remember testifying to that?
Yes, sir.
And do you remember Mr. Wilkins asking you about questions about different fonts and different placement? Remember that?
Yes, sir.
Right. Do you remember Mr. Wilkins asking you this question? Now, when you first got these photos, did you attempt to try to find the website on there? Do you remember that question?
Yes, sir.
And you testified, yes, sir. You remember that?
Yes, sir.
And then do you remember Mr. Wilkins asking you, how'd you do that? And you testified, I just typed the address into one of our computers in the office. Do you remember that?
Yes, sir.
And do you remember Mr. Wilkins asking you, and what did you find? And you testified that the website no longer worked. Do you remember that?
Yes, sir.
And then do you remember Mr. Wilkins asking you, so you put belladondigiorno.com escort site and put it in your computer, and you responded, yes, sir. Do you remember that?
I believe so, yes, sir.
And he asked you what happened, and you said, it just redirected me to another escort website. Do you remember that?
Yes, sir.
And then then he asked you, were any of those photos on that escort site? And remember, you testified no.
I'm sorry, I got an objection. Can I
I'm almost done. I'm one more line.
I'm going to let him ask this question.
Do you remember Mr. Wilkins asked you, were any of those photos on that escort site? And you responded, no, sir. Do you remember that?
Yes, sir.
And then just one more. Do you remember he asked you, was any pictures or were any pictures of Christina Parcell on any of those websites that you found? And you testified, no, sir. Do you remember that?
Yes, sir.
Are we going to impeach here? Is he impeaching with a photograph from a website? What do you say? Defense did their own research and look what we found?
Isn't it true that in the harassment report that I just showed you, Defense Exhibit
Your Honor, I've got another objection I need to make. I need to put it on the record.
Your Honor, this is
I'm sorry.
Okay, the state can smell whatever defense is stepping in, and they don't like it. They're trying to stop this before they get there. This is impeachment. This is impeachment, and apparently the defense is trying to get an angle. They need to get an angle to open the door, right? If the state opened the door, they can go in. You can tell from the nervousness of the defense attorney, he's walking a fine line. Is he going to pull out pictures? He could. We would hopefully not see those because that would be the end of the channel. Why didn't he bring that up during cross-examination? Well, it could be a couple of reasons, but it's possible they didn't discover it till now. It's possible they weren't expecting him to give that answer, or that answer where he said to the state that we didn't find any of those pictures on those websites. That may be the first time the defense heard it, and so they would have to go and then do their own research and then say, okay, actually, isn't it true that there were? This witness could open the door. I think they're trying. They're trying to find at least some wiggle room. You can see how much they asked him about his previous job and about his training and exactly what his specialty was, and wasn't he trained in that area. That's foundational, but they're planting seeds. They're like, jury, I can't say this, but listen, right? Listen to what I'm talking about. Listen to what the next question that I'm not saying. I want you to hear and connect the dots. DiGiorno pizza, cheese pizza is ruined for me forever after this case. I am trying to work with a little bit of a delay on the stream. We'll see if I've got it set up correctly to catch something, because I don't want to be in trouble. One wonders if they found photos online when they were put on when were they put online before or after the demise of the victim. The witness is being very careful. The witness is fully aware of what he cannot say, because he was briefed previously when he was called on the stand by the state, saying these are the areas you cannot go into. You are prohibited from mentioning anything. And the witness isn't going to just like blurt it out like that. But there's a possibility that step by step, the wedge, the little door can be cracked a little bit, and then that wedge can be worked wider and wider within the confines of Judge. Now that they've said that, now we have to ask this. Otherwise, it's a prejudice against my client. It's possible that he can get this in and blow the door open. But if this witness found pictures than it was before, yes, Jojo, we're in an objection right now. The state has objected 3 times, I believe, to what's happened. Was it 3 or 2? Did I click too many times? 3 times today. We were started at 21. Now we're up to 24. Diane, by the way, tried different words. Oh, well, thanks. Diane, there may be a word in there that we have banned words, which some of them are not bad on their own. Okay, there's just a word that for some reason we've said it's used in a certain context and it's bad. So I'm not trying to tell you how to find your way around it, but Judge is looking intently. How's this going to go? Is the jury leaving?
So again, let's pick up where we left off.
Is this a
I
proffer?
had reminded you of your testimony from last week, wherein you were asked the following about typing in this website. And you were asked what happened, and you testified it just redirected me to another escort website. Then you were asked, were any of those photos on that escort website? And you testified, no, sir. And then you were asked, which you previously testified to, were any of the pictures of Christina Parcell on any of those websites that you found? No, sir. Do you remember that testimony?
Yes, sir.
Isn't she in your report on the harassment allegations?
Your Honor, leading.
Your Honor, he's an adverse witness, 611C. He testified for the state. He's a member of the Greenville County Sheriff's Office. I have every single right to lead him pursuant to the 611C.
Your Honor, he's their witness. They called him. In a direct examination.
Witness, so I'm going to sustain the objection.
Sustain the objection to leading.
All right. Well, I'm going to show you Defense Exhibit 65 again. Look at this bottom paragraph. Would you please read what I have bracketed to the jury?
Yes, sir. I photographed the 6 envelopes and the contents of the open ones. The open ones were addressed to Brad Post. One contained black and white nude images of Parcell with the address checklist. The images have a web address of http://belladonna.escort-site.com. I checked this web address and it was not valid. It redirected me to another escort site under a different URL. The other contained several of the same images but were not in color.
So is it true, based on this report, that you were redirected to other websites that had the same images that were in those envelopes? Isn't that correct?
No, sir.
Okay. Isn't that what you said in your report?
That's poorly worded on my part, but I meant the other envelopes. The same images were not in color.
What are you saying you meant?
The images that were in the other envelopes, not another website.
So didn't you say that you found these on the internet? Isn't that what you said in your report?
No, sir.
Tell me again what you said. Yeah, please read it again for the jury. Read it again.
Okay. It's okay if I go to the relevant part instead of
Yeah, and I've got a bracket there.
Okay. Photographed 6 envelopes and the contents of the open ones. The open ones were addressed to Brad Post. One envelope, or it just says, one contained black and white nude images of Parcell with the address checklist. The images have the web address of http://belladonnadigiorno.escort-site.com. I checked this web address and it was not valid. It redirected me to another escort site under a different URL. The other contained several of the same images, but were in color. Now, like I explained, it's poor wording on my part, but I was referring to the other envelopes contained several of the same images, but they were in color. I wasn't referring to another website.
And in your report, you don't distinguish between envelopes and websites, do you?
Like I said, it was just poor wording, but I was referring to just other envelopes had the same images, just in color.
And isn't it true that it is very possible that those images could have been online and just taken down at the time you tried to look at them? Isn't that true?
In another website? Is that what you're referring to? Yes, sir.
Okay. The poorly worded report comes back to bite you in the butt.
Those are all the questions I would ask Investigator Bevel in this context. I don't have anything further on the examination.
You want me to please the court briefly? Did you ever find naked photos of Christina Parcell on the internet when you checked?
No, sir.
It's because they didn't exist that you could find.
Not that I could find.
No further questions.
Nothing else, Your Honor.
Okay. Defense swung for the fences and missed with that witness.
Your Honor, there is, Your Honor, pursuant to your previous ruling, I would like to present some information in the absence of the jury.
So now jury goes back out, and under judge's rule, we might not hear this. We'll see if we'll be able to. All right, so now it's helpful that we have people there in the courtroom who can give us some updates. Let's see, pretty lies and alibis. Let's see if they've got. Let's jump back through this last half hour. The state says the defense called the investigator to impeach his testimony, and they had the opportunity to cross. Judge will allow defense questions to Investigator Bevel. We saw that. Pretty Lies and Alibis continues on Twitter. Also, he filed an emergency protective custody for the child to be removed from her aunt's home due to imminent harm. The jury sent back out on the record what he would have asked the investigator, that it was confirmed Christina was seen in the child abuse materials, and goes through each charge saying those are considered violent crimes in South Carolina. Also, he filed an emergency protective custody for the child to be removed from her aunt's home due to imminent harm. Defense says they'd also ask that John Mello made a report suspecting his daughter was being abused. The witness saw the photos of the abuse from January 1st through October. From January 1st of 2018 through October 19th of 2021 after the murder. Yet when Mello made the report, the investigator emailed John Mello that he was closing the case due to lack of probable cause. So essentially, the defense is saying that the abuse was happening, but the investigator didn't have the phone at the time with the images because the murder hadn't happened yet. So maybe trying to attack this investigation into the claims is my guess, says Pretty Lies and Alibis. Defense was also going to call the owner of a cigar bar. Wasn't that Christina's dad? Who found more child abuse materials after Bradley Post's arrest. The judge won't allow the testimony, but the defense is summarizing what he would testify for the records. This is just preserving for the appeal. The owner of the cigar bar won't testify, but would have said, after Post's arrest, he looked in Post's locker at the cigar bar, found multiple hard drives and thumb drives with additional child abuse materials found on those. So, building a strong case for appeal, for sure. Let's see. Jury has got to be wondering what the holdup with defense is. So look at this. Look at how the defense has had to dance around this issue. They are not allowed to bring up that's the subject of the other investigation. They've tried to, get as close as they can to the line. Every time they get close, the state objects, the judge sustains, and then they have to try a different angle. It has not worked yet. The problem is, without getting that in, you put the defendant on the stand. He admits, as you've already told the jury he's going to, and say, I did it, but I can't tell you why, because the judge won't allow it. That would throw objections like you would not believe. Oh my goodness. I did it, but I had a good reason. Which I can't tell you. Laura Bronson, huge super chat. Love you, RA. Just looked at the appeals hearing for the Take Care of Maya cases. Glad it's moving forward. That's good. Yep, that's wonderful. Hoping that gets resolved. I think the family needs to be paid out. Needs to happen. The mom's history is not coming in because it's not probative, but prejudicial. The defense of a child is specific to an interested party, like a father, not a friend. No. I'm not sure if he's going to be able to say that. Is he able to walk in there and say, no? Well, the judge ruled no. He can't go in and say, I was defending another person. Because South Carolina law, there has to be some degree of exigency. It has to be in the moment, right? The child was not there, was not home. The child was at school when this happened. And to say, I had to, that's basically what he's saying. I had to use lethal force to defend this child under South Carolina law. Nope, you didn't. There was no threat to the child in the moment. And you can only do it in the moment. Shadow member for 7 months. Bet the jury is trying to read between the lines in this. I bet the eyes are wide open. This is crazy. Tickled Pink. There were suspicions, but there was no evidence. They didn't have the evidence until after the murder. They found the first evidence on Mr. Post's phone after the murder. So that's when they found the evidence, and nothing happened before then. So same dance around with Karen Reed with the FBI. Guess that old lady neighbor witness got eagle eyes after all. Yeah, apparently she saw what she saw, and she remembers. Bay bars. Yeah. I wonder if the judge can consult other judges, et cetera, to get their opinion on all of this prohibited evidence. I believe they can, but he can't use an outside judge to make a ruling. So they can consult, with law books. They can consult with precedent cases, Supreme Court cases. They can review those, and they can consult with whoever they want, but they have to make their own ruling. They're the ones who have to stand on that. I think he made a mess for himself by saying he did it. I don't think anything will be overturned, even if the appeal is granted. The premeditation mucks about with the defense's theory as well. Can the defense call the daughter and still tap dance? The judge is going to rule that you can't just call anybody to testify. You can't just rip somebody in under subpoena, stick them down in the chair, and ask them questions that are not relevant to the case, right? So if you're going to call a witness, especially a child witness, the judge might say, tell me where you're going with this. Tell me why we should allow you to add this witness to your witness list in this late hour. And if it's just, I just want to see what she says, meh, not going to happen. Can it be a crime of passion? Crime of passion is a little bit different. There's no indication that the defendant and the victim in this murder trial had any sort of relationship. Pop rate. All he can say is, I did it believing I was defending someone else who couldn't defend themselves. I don't know. Anything he says beyond I did it is going to be objectionable. This case is a cluster. Yeah. He might be next on the stand. The other jewels, all we know is that the opening statement, which we heard right before lunch today from defense, because they deferred that until the second half of the trial, or their portion of the trial. The opening statement, he said, what you're going to hear to the jury over the next day or two is the following. And a day or two is probably a couple witnesses. I would be very surprised if the defendant was on the stand for a day or two. So, but now we know of at least two witnesses who are not being called: the daughter, the victim, and the cigar owner. That's two that will not be on the stand. Okay. I have a feeling he's going to blurt it out before the objection can come out. Okay. Living ghost. Oh. If that happens, first of all, we're going to be looking at the seal immediately. The jury's going to be kicked out, and we're going to be looking at the seal, and it might be a long, long while. Josh, thank you. I'm keeping an eye on Twitter here. Latest and greatest is also from Gigi from Pretty Lies and Alibis. The state is summarizing the testimony that would have been given from former guardian ad litem to the child, investigator, owner of a cigar bar, who found hard drives in Post's locker. Then another would describe Christina in many photos with her daughter. That's what we are not hearing right now. When is Brad Post's trial? I don't know. He's in custody. Post got convicted and pled, I believe, so I trust the validity of that evidence. Oh, if he's serving a sentence right now? I thought it was pre-trial. But if he pled guilty, then it's a done deal. Brittany, yes, of the worst kind. Could Josh's lawyer intentionally cause a mistrial and try it differently next trial, even if lawyer gets sanctioned? Well, the sanction would be a fine on him, right? He would be fined, maybe reprimanded. I don't think they could punish Josh and say, or sorry, not Josh, punish Zach and say, in your next trial you can't use this defense. I'll rise. I don't know anything about other lawsuits. His best appeal chance will be ineffective cancel, in my opinion. Josh, Zach, same thing. The problem is we talked about courtroom confidential, and that's Josh, and now that's a four-letter word, and then we've got Zach, which is a four-letter word, and we're mixing the two up. Love courtroom confidential. Not a big fan of Zach. Why can't they bring in the cheese pizza? The judge has said no cheese pizza in my courtroom. It's not coming in. It's too prejudicial over probative. Barb Russell, what's going on right now is defense. It could be because it's their case. Defense is saying, Judge, you're ruling that we can't call the witnesses we wanted to call. And I'd like to put on the record, because we will appeal this. This will go to the in our appeal. And we want to put on the record what would have happened. That way, when the appellate court looks at this appeal, instead of just saying, hey, they said I couldn't have this witness, they can look at what the witness would have said and the impact it would have had on the trial, or could have been presumed to have had on the trial, and say, oh, yeah, that is major. That is big. Yeah, that is a problem. So they're putting that on the record now. The jury doesn't get to hear it. It's just for the judge to hear. People in courtroom get to hear. The state gets to hear and argue their side as well. But it's just for the appeal. All Joshes are definitely great. Josh as well. Josh Hutchins, our wonderful mod. Can we just talk about what is being presented in court? All cheese pizza comment says me sick to my stomach. That's right now what's being presented in court, Mandy. That's why. That's what they're talking about. Renee, no. Pizza is good when you're talking about real food. I wish the judge would allow anytime he's on the bench that we're able to see, aside from sidebars. No, the daughter did not testify. I think the judge ruled that was not going to happen. Or if the judge didn't exclude the daughter, he said the testimony that she's, we assume she's going to give is not allowed. So I'm not going to allow it. They did not present that in court. Mandy, what I'm saying is right now, as we're looking at the wall, we're looking at this. In court, they are talking. The jury is out, and because the jury's out, we don't get audio and we don't get the picture. In court, they're talking about these things. They're saying this is what they would have testified to. And we're getting that confirmed from our court watchers who are in a court watching this right now and updating us on Twitter. Hang on, just trying to respond to a text really quickly. Okay. This judge excluded too much. He decided what was too much and took away the motive. That's what defense is going to say in their appeal. I think the bigger issue is in South Carolina. for this to be a defense of another, there has to be that imminent threat, and it's not there. There's no imminent threat to the daughter. I believe the guardian ad litem dropped the ball. Mr. Opetorso, that's a good point. I don't believe Zach has firsthand knowledge of this. It's all been passed to him through probably Mello and dragging the daughter up. Like you put it as a crapshoot. Yeah, that's a low trick. My problem is he stabbed her 31 times. Sherry Smith, this is also true. We mentioned that a little bit earlier today, that this was not his defense from day one. He was not saying, I did it because when he was first arrested or first turned himself in. He's always been, prove it. That's been his defense. Don't cooperate with the police, prove it. And that's the right thing to do from a defense lawyer's standpoint. But to go this far in the trial and then raise the issue of, oh, this is why I did it. It seems like you spent a couple of years, hammering out some story that would seem somewhat believable based on the facts that are against you in this case. And you're hoping to win some sympathy that way. Nikki, I'm not sure if in South Carolina he's required to disclose this before. The fact that the judge restricted it, it seems to indicate that there was at least some degree of, you should have said this before, this should have been erased before. Sinbad, I'm hearing that Brad Post pled guilty, which means no trial. Does the jury or the judge hand down the sentence? What happened in Murdaugh's case? Because we're back in South Carolina. Oh, he's only charged? Okay, thank you, Mr. Upper Torso. If he's only charged, then the case is still outstanding. I'm surprised he would testify if he's got charges against him, though, instead of pleading the fifth. Judge Newman lowered the hammer on Murdaugh, so the judge gave Murdaugh's sentence. We'd expect the judge to give the sentence here as well. What are we doing? Proffer of the investigator? I think the investigator is done. According to the tweets we're seeing from inside the courtroom, the defense has been going over the testimony they would have received from Christine's dad and from the child, and what they would have gone into with this defense, the investigator, the witness they had on the stand, if the judge had allowed them to go further. See. Judge isn't allowing Mr. Hughes to bring in the issue involving the child as for his defense and reason for killing. to protect her from her mother and Bradley Post. That's not why the judge is doing it, but the judge is not allowing that argument that I was trying to protect her from her mom and Bradley to be raised. So all you get is the defendant takes a stand and says, I did it, but I can't tell you why. It's not allowed. And I'm not sure if he's even allowed to say that. I mean, jury, take my word for it. I had a good reason. So find me not guilty. I had a really good reason. Just trust me on this one. That's what that's what defense is left with. Judges hate it. Judges hate it. The basic, I think, premise behind jury nullification is that when you sit on a jury, you are a trier of both the defendant and the law that the defendant's being held up against. So if the law was bad, say for instance, there's a law that says you're not allowed to breathe on Tuesdays. Yeah, that's a bad law. The state might be able to prove in a court case that someone was breathing on Tuesday, thus they are guilty, and then present it to the jury under the law. They met the standard. They proved they were breathing on a Tuesday. You should find them guilty. Instead, the jury can say not guilty because it's a bad law. And juries are not instructed about that, and it's a point of heated contention. Man. Do you think defense jumped the gun on the I did it statement? Should have waited for the judge's ruling. Oops. I think they had to say something. I mean, in the opening statements, they had to sort of act as if that was going to happen. That was probably their best bet to try to get this information out, was to say, here's what you're going to hear. You're going to hear why. And then the judge is going to rule after they watch the state object every time they get to that point that they can't tell them. And they're just hoping the jury puts things together. If the jury solves this one, it's from outside information. And that's not how the law works. It was a worst Hail Mary. It was a Hail Mary with none of your team downfield. They're just throwing the ball, hoping that it bounces off the opposing player's head and comes back to them. It's a terrible, terrible strategy. But it might be the only thing they have. Yes, the witness that we just had called by the defense as their first witness worked in the ICAC. See, the ICI, it goes like this. They call it ICAC. ICAC. He worked in that area, and he asked a lot of questions about that, trying to focus on that topic without asking about the investigation, because that was his background. But then when he tried to lead the witness to a certain point where the witness did not want to talk about it, is not trying to blurt this out. When he tried to lead the witness to sort of get in that door, the state rightfully objected because he's leading the witness. And you could do it on cross, but you can't do it on direct. You can't lead your own witness. And he says, oh, this is a hostile witness. It's like, no, he's been answering your questions. He doesn't appear to be hostile in any way. It might be, somebody on the other side. But hostile witness didn't fly either. I think the Smith, I think something shady is going on if I was on that jury. Do jurors know that he did it? Well, they were there when the lawyer said that he did, and he had a good reason. So I think, the jury knows now. They just haven't heard. Now, what the lawyer told them is not evidence, right? That's an opening statement. That's not evidence. They are waiting to hear it from actual witness on the stand. So Zach would have to take the stand and say it for the jury to actually have that in evidence. Defense should have questioned him on cross. They would have been able to lead better, but it's possible they didn't know. It's possible they didn't know what he was going to say and weren't able to prepare the questions ahead of time. But then again, he explained everything quite well. There was no impeachment material for him. Angela says the real victim in this case is DiGiorno. Understand the statement prejudicial over probative, but why not letting evidence in? Well, that's the judge's call. He's the referee that decides between prejudicial and probative. There can be some probative information that has a little bit of prejudice to it, and if the balance leans on the probative side, he can allow it in, even with the prejudicial aspect. Becca, the stop and start happens because the judge has made a ruling, and I think it was a change to the media guide during trial, because we used to see some of what happened when the jury was out, but he's made a ruling that we cannot hear or see the proceedings in court if the jury's not present, and I think that's a bad ruling. I want to appeal that one. I think we should be able to see everything that the public can see. Do I think this is leading to a mistrial? No, I think it's leading to a pretty good appeal argument, but that's after conviction. I was so confused when the defense implied that the guy riding the bike was not Zach. Zach's short, apparently. The defense attorney is 10 feet tall, and Zach is shorter than him. What? Jury's being sent home? Jury's being sent home for the day. We have issues. Carter. No. Oh man, we've had 15 minutes of court today. And a whole bunch of spice that happened off camera. I was hoping for good fireworks this afternoon. I was hoping to maybe hear from Zach this afternoon. Jojo, I'm violently hitting the keys on my iPad. Oh my goodness. Is this the trial that the cameraman was spending 10 days in jail because he showed the jury? All right, they all get. Hang on. Wasn't that the that was the previous one. That was Griffiths, wasn't it? Griffith? It was Megan Boswell? Okay. Boswell seems like a year ago. Oh, the one bug was that. Well, they're not wasting the jury's time anymore. The jury's been sent home for the day. We want a refund, Judge. We bought our tickets and we didn't get the show. I think we have Christy in the courtroom. I'm hopeful that she's able to call in. Hang on one second. Okay, I need to charge my phone, or else we're not going to be able to get any calls. Thank you. Okay. Jury is gone home. Paige and Christy, call in, please. Paige and Christy. We're just gonna wait. Apparently, we'll hear in half an hour. The jury gets sent home. Compensation. If only there was a cable to charge the phone. Walker. My intent was pure. It's going to be so packed. It's going to be so packed. Maybe, tell you what, let's do this. Let's, Josh, maybe we can go and get the video you shared for us, a palate cleanser. See if I can grab it here. So, Josh, when did that happen? Do you know? Let's see. That was 1503, so 2:30, 2:45 ago. So I go back 2:45. Okay. I'll try to get a palate cleanser here. There's like nothing happening in this courtroom. It's just live with nobody on the bench. What's the name? Or Josh, can you give me a screenshot or something? We had our objections to the counter. Who do you think will write the movie script for this case? Oh, my goodness. It's Judge DeSanto. Let's see. That's where we're trying to go. I'm not seeing Josh. Look at Stevie Post. Stevie's post is gone. Let's see if this is it.
1962.
Good morning, Your Honor. Paul Young's on behalf of Ms. Thompson.
Good morning. Good morning. Your name, please.
Allison Blair Thompson.
Okay, good morning. Okay, and so
don't think this is it.
Scheduled for the probation violation hearing, and counsel, on the 28th, you were able to speak to Ms. Walker in the breakout room, and then you were requesting specific.
Yeah, that's not it. Let's see. Give me a second. We'll see if we can get right to it. It is. Okay. Give me a screenshot so I can find it. I'll give you hints. There might be a swing involved. There we go. Okay, here we go.
Oh, there's Shanky.
Good morning, Mr. Shumke, or good afternoon.
Good afternoon, Your Honor.
All right, and okay, so we're just waiting on Mr. Robinson is present in person. Have you spoken to him?
I have, Your Honor.
Okay, good morning, good afternoon, Mr. Smith. Hi, Deputy Provenci.
Good afternoon, Your Honor. We just got the one for you, Kevin Smith.
Yes, we are getting ready to log on.
Good afternoon, Your Honor.
Good afternoon, sir. Okay. Hi, Scott. How's it going? Good. How are you?
Good. Freezing.
You're freezing?
Yeah, I've had my share of winter.
Oh, okay.
Like for the next month and a half, I'll be freezing. Okay. You want me to get Allie? She's gonna have to be in here for all this, or?
No, I just
Okay. So Collins is not gonna show, but we have.
Oh, she's not?
No, after all of that.
Okay, well, I guess I'll do this one on the record and then we'll call them in.
Okay.
So if you want to just have them all come in,
So
that's
have them
fine.
all come in?
Yeah.
Okay.
Did the attorneys have a resolution or no?
He wants to, no, he's going after default, so.
Okay.
Yeah, so we'll see. They're talking right now, but I don't think there's a resolution.
Okay. All right, we are going on the record in the matter of the City of Wyandotte versus Christopher Robinson, 241523.
Good morning, Your Honor. Christopher Shemke, appearing on behalf of my client. This time we consent to the matter being heard via Zoom for the defense, but my client is in person. We are prepared to proceed.
All right, and good morning. And, good afternoon, and sir, your name for the record, please.
Christopher Robinson.
All right, thank you for dressing appropriately for court. And counsel, today is the date scheduled for sentencing on your client's plea to an amended charge of operating while visibly impaired by alcohol. Did you have an opportunity to review the report and recommendation with your client?
Yes, Your Honor, it's factually accurate.
All right, and you may proceed.
Your Honor, as to the recommendations, I do believe they are appropriate, and my clients are extremely well on bond. I have no reason to believe they won't do equally well on probation. I respectfully request the terms and conditions be adopted and potentially be put in a position for consideration for early termination. And then as to costs and fines, if necessary, I am respectfully requesting a payment plan. Thank you, Judge.
I think it's one right after this.
All right, and so Mr. Robinson, if you were to test today, what is in your system?
Nothing, Your Honor.
Okay, so I understand that where you work, sir, you're a driver. You CDL?
Yes.
Okay, so have you already looked into what those consequences will be regarding your employment?
Yes, ma'am. I switched to a chauffeur's and I drive a van now.
Okay, all right. And the court will note, after having heard from counsel, having heard from Mr. Robinson, reviewing the report, the recommendation that, I'm sorry, in the criminal history and the police report, and the court does find there's reasonable grounds to cover MCL 769.5. The court also finds that the following sentence is in the best interest of justice and is reasonable and proportionate to the seriousness of the matter and the circumstances surrounding Mr. Robinson in light of the legislative guidelines. The court's going to order 12 months probation. You're eligible for early discharge. I'll go over that in just a few moments. You're not to violate any criminal law of any unit of government. You're not to leave the state without the consent of the court. You are to report truthfully to your probation officer as often as your probation officer may require, in person, writing, or virtually. So let me just ask you one question. Do you travel outside of Michigan for work?
No, Your Honor.
Okay. You've notified your probation officer immediately by any change in address or employment status. You are not to use any alcohol or drugs unless prescribed to be subjected to random testing. The rehabilitative goal for that condition is so the court can monitor your progress in maintaining abstinence and sobriety. The court is going to also order that you are to enroll and participate in outpatient substance use counseling. The rehabilitative goal for that condition is so the court can, or so you can have assistance in providing coping mechanisms to maintain sobriety. Hopefully preventing relapse and having this matter happen again. The court is going to also order you to participate in that management impact panel. The rehabilitative goal for that condition is so you can further increase your understanding of the dangers of driving while under the influence, as well as familiarizing yourself with the consequences of such behavior. And then the court's going to order 75 hours of community service. The rehabilitative goal for that condition is to help you further develop life skills and give back to the community. Any questions regarding the terms and conditions?
No.
Okay. The court's going to order a $300 fine, $100 screening assessment fee, $600 supervision oversight fee, that's $50 a month at 12 months. Since you're eligible for early discharge, up to half of that could be waived. $300 for the cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50 for a total of $1,425. And you did post a $250 bond. Do you have any other money to pay today?
No, Your Honor.
Okay. So let's, okay, that leaves a balance of $1,175.
There's our
when you
defendant.
apply your bond today.
Or these are our
How much do
two.
you pay per month and what day of the
Right
month
above
works
this-
best for you?
This lady,
It's possible I can pay it all off by next month.
Okay, yeah, I'm going to have you back out $300 of that though, okay? Because if you discharge early, then you won't have to pay that $300.
Okay, thank you.
Okay, so, all right, let's do this. Can you do $200 a month in the event you don't pay it off?
Okay.
Can you do
Yeah, that's fine.
$200 per month? Okay. What day of the month works? Does the end of the month work best?
Come on, we're trying to skip ahead.
As I did indicate, you are eligible for early discharge as long as all of the following have occurred. You've completed at least half of your original term of probation. All probation. Okay, have you spoken to Mr. Foley?
Here we go.
File over. Do you have any questions?
No, Your Honor.
Okay, I know I went over some of that pretty quickly, but probation will go over that with you as well.
Thank you.
All right, good luck to you, sir.
Thank you.
All right, thank you. Just
Buckle
have
up.
a seat over in probation, okay?
Buckle up. Here we go.
All right, thank you. Let's go off the record. Mr. Shemke, have you spoken to Mr. Foley?
Foley.
Edward Foley?
Good.
I'm sorry?
I'm looking now, Judge.
Oh, okay.
Yes, I have, Judge.
Okay. All right. Mr. Foley, we have you checked in. Mr. Foley, please unmute and turn on your camera.
There he is.
Okay.
All right, good afternoon. We have you checked in. It'll be just a short while.
Okay, thank you.
Thank you. Mr. Taylor, good afternoon.
Good afternoon, Your Honor. How you doing?
Good, thank you. How are you?
So far, so good.
Okay. All right, so you're here for Mr. Smith. Were you able to receive the money for the bus ticket?
I have, Your Honor, and I talked to his sister, and they got a one-way they got a one-way nonstop to New York, and that's what I was trying to get, but it only leaves at $12.20 per day, so I'm gonna have to get him and try to do it tomorrow.
Okay, so I'm going to put you in a breakout room with Mr. Smith, and then I have a couple matters, and then I'll handle yours, okay?
Very well. All right.
Okay,
No
so Mr. Smith, please unmute.
We're looking for the one.
You're good now. Okay.
We're looking for the case with the lady in court.
In the breakout room one.
That's her. I think.
And then we are going to go on the record in the matter of William Branson versus Heather Collins, 2402269.
Ready, Your Honor? Good afternoon, Your Honor. I'll endeavor Mr. Branson, who sits to my right.
All right.
Good afternoon, Your Honor.
Good afternoon. And your name, sir, please?
William Branson.
All right, thank you. And counsel?
Good afternoon, Your Honor. My name is Micah Dalbala, appearing on behalf of the defendant. She did request 8:30 in the morning at the last hearing because she works at 11:30. I didn't get notice of adjournment till Friday. I sent a subpoena to a witness on Thursday that I filed with the court. I've been trying to facilitate adjournment, but I have to officially ask the court for that.
Okay, so the court will note that I originally, we were trying to do a date, not today, and then counsel was going to be unavailable. And then I picked today's date, and it was my mistake of picking 8:30 because I had already committed to serve as a panelist on a career conference day at Wayne State University. So I was there this morning, and it was my fault that I set that time. So once it was determined that there was a conflict, then communication was sent to your client. It was sent to you once we received your appearance. So that would be why you received that information on Friday, because that's when we received your appearance. And so there was plenty of notice provided to your client where she could have potentially just asked about going into work late, having somebody cover for her for an hour or two, I'm not sure. But before we get to the request for adjournment, did everything occur that was supposed to have occurred regarding the
You ordered in.
Let's see here. Number one, I ordered the parties to brief the issue of no certificate of occupancy and collection of rent. Counsel, did you submit yours?
I did, Your Honor. It's titled Memorandum of Law, and the date of filing was 2/14/2025 at 10:45 a.m. I believe both sides have submitted memos, Your Honor.
Somehow it's not showing in here.
I can approach with a copy for the court.
Okay, just one moment.
Told this gets spicy, so buckle up.
And
Or
then,
we can email it to you now, Your Honor, if you want. Whatever is more convenient.
well, then I also indicated that
An inspection?
there was, yes, counsel, please let me make the record, that
Don't interrupt the judge.
The parties were going to meet where Mr. Branson was there to have an independent, they could each have an independent person, so Ms. Branson was not to be present, and there was supposed to be an independent person there with Ms. Collins to go over what the issues were regarding the repairs that need to be made. There was permission to take some photos as well, but they were not to video or photograph each other. So, did that occur? Because I believe that was set for Saturday, the next day, Saturday.
Friday at 5 p.m.
Friday at 5 p.m.
Yes.
That's right. Okay.
In fact, it did occur. And what happened is...
No, I don't know what happened. I just want to know if it occurred.
It occurred with the assistance of the Wyandotte Police Department.
Ooh.
I must state something for the record.
Okay.
Plaintiff was actually, I don't have a copy of a written order and I wasn't here, so I'm at a little bit of a disadvantage, of course.
Okay.
Plaintiff, of my understanding, was in violation though because he brought 2 police officers with him. This woman's already being, sexually harassed by her landlord. And,
Hold on.
Sorry.
Hold on a moment.
For safety
Your
reasons.
your client had made allegations regarding various types of harassment or assaults, indicating that those are being investigated. I don't have any information or basis for any of that. So counsel, please, we're not going to go there.
I'm not trying to bring those claims to this court. I'm trying to explain that under the order, and as you described it, there was supposed to be one independent person with each party. She's in significant emotional and mental distress because of her living situation. And then she has her landlord come with 2 police officers instead of an independent person. So plaintiff is in violation of what the court ordered. And it's having a deteriorous mental effect on my client, who's now being put through the ringer in court that, she's not credible because she's suffering from abuse.
Your Honor.
Well, first of all, I haven't said that your client's not credible.
Yeah.
I haven't said that at all.
Okay.
Sure.
Fair enough.
Yeah, address.
But I also...
That caught the judge's attention.
I will say from an outside perspective that I don't know that there could be any more independence as far as independent individuals than the police department, because they don't have any stake in any of the games.
I appreciate that. And she's been made aware of that, but the problem is that it's a very tenuous situation and the court ordered that one independent person come. And that's not what happened. The landlord brought 2 police officers with him. And that was video camera evidence. Even though it's from the police, there's a cam. They wear a cam. Yeah.
Okay, well, when I said no video, I meant I didn't want each of the parties to video the other party, thereby exacerbating any issues that were going on. That is what this court was intending, because your client was improperly recording the proceedings when she was here last time as well.
I understand.
So I wanted to make sure that neither party was exacerbating any issues or trying to instigate any provocation from the other side. That was why this court ordered no videotaping of the other individual. However, they could take photos of whatever issues needed to be repaired, but they didn't need to have the other person in the video or in the photo.
If I may.
So my first thought is that if there's 2 police officers there as independent witnesses because they don't have a stake in any of it, I'm not sure how there could be any more independence by that. Did your client have another individual there with her?
Honestly, I'm not sure, but she certainly didn't call the police. And if the order said you can have the police present, then I wouldn't even be discussing it. It's not that I'm trying to cause an issue. I need a simple adjournment. I need to get some fairness for my client. And
I'm not saying I'm not going to get the adjournment, counsel, but I'm just trying to understand if any of the things that this court had ordered occurred.
That's hard for me to know precisely.
Well, but I'm also going to say this, that I don't know that there's a violation of the order of this court's order regarding, and really I didn't say they had to have an independent person. I said they could each have an independent person. I didn't say that they had to have an independent. I didn't say they had to have anybody there. I said, if you choose to have an independent, a person there with you, right? Because I thought that would probably be most beneficial for both of them. It has to be an independent person. And there are what they call civil standbys, right? So there's individuals that may be going to a property to, if the court ordered they can't return back to the home, they take the police with them to go retrieve some of their personal belongings or what have you. So I don't necessarily know that that's an improper person to have there during the time that the photos are being taken. I'm not sure.
Yeah. Guys, Judge, I think the reason she's objecting is because we've submitted the body cam of the police officers. Now, let me back up.
Wait. Where did you send? Where did you submit the videos to?
Your Honor, there were.
No, Mr. Foley's on Zoom.
No, Mr. Harper.
Okay.
Mr. Harper.
Where did you submit the body cam to?
Your Honor, what we've done is that I've answered her motion to.
No, counsel.
It's part of.
Where did you submit the body cam?
It's part of our response to her motion to dismiss. It was emailed.
Who filed the motion to dismiss?
My client filed an amended motion to dismiss.
And so
when did she file that?
Well, she does not understand the court system or e-filing, so I filed it as an exhibit because a brief was ordered. So my whole position is very convoluted. I have a brief and I have an amended motion to dismiss attached to it.
Your Honor, if I may,
okay.
the motion was properly filed. It was properly filed, but not timely. You had ruled on that already. So you had a copy of the motion, and then
No. I didn't rule on the motion to dismiss. I say that I wasn't going to hear the motion because it wasn't properly, there wasn't proper notice. So I didn't dismiss the motion. I didn't do anything on that. I simply indicated I was not going to hear that on the 11th of February because it had not been properly noticed or hadn't been proper notice. So I didn't rule on the motion. So let me just clarify that for the record. I did not rule on the motion.
That's correct, Your Honor. I wasn't inclining to say to you that you had ruled on anything. I was merely saying to you that when she appeared here in court, they took the motion and they filed it. And I was about to say exactly what you said, so I'm not going to repeat it. But in answer to your question, Your Honor, we had submitted a Dropbox that contains the body cam of the police officer, and it was emailed on Friday at the same time that we filed our responses to a D. Peryaski, P-A-R-Y-A-S-K-I.
Oh, yes.
Yep, at wine.mi.gov. And so the drop link that's there will allow the court to perfectly view the body cam video. And I think, let me tell you why you need to view the
Well,
body
hold on.
cam.
I'm going to tell you why I'm not going to view it right now because it's not properly submitted as an exhibit to a motion. I'm not going to view a video that's just been submitted as a response to a motion or that's been emailed to the court because there's still the evidentiary rules that the court needs to follow, and that's not properly before the court right this moment.
May I address that?
Okay.
Like I said before, this was in response to the motion to dismiss. And hopefully you'll take an opportunity, because I know this was filed late on Friday, to review all these documents between now and the next time we return. But in terms of evidentiary, Your Honor, it is not hearsay. It's not an acceptance.
Objection, we shouldn't be going into the details of the video.
I'm not saying that.
No, respect.
Hold on. The court's going to overrule the objection and the fact that it's a bit premature because there's not been a video offered for evidence at this point. I'm stating that the court's not reviewing the video right this moment that was submitted with your response. I don't even have that loaded on here. Potentially because it was done late Friday afternoon and there's probably 15,000 steps that has to happen from the e-filing once it gets put into here, and Ms. Peryaski is out ill, and so it's not on here. So I want to state for the record, I have not reviewed the video, nor am I going to review it right now because I haven't had an opportunity to review the response, and there needs to be a review of the foundation before the court can view the video.
I agree with you.
So I'm not going to talk about whether it's excited utterance, whether it's not hearsay or anything of that nature. Okay?
In answer to, you had asked when it was filed, and we've answered it. You had asked how it was filed, and we've answered it.
Right.
And then the issue of whether it's admissible or not was raised. I was addressing that specifically.
Right, and I can appreciate that, counsel,
Yes.
but right now is not the time to address the admissibility of it because I'm not hearing the motion right this moment.
I understand that, Judge. All right, so the next item I want to raise is the pragmatic part of this. In our response, we were able to locate the invoice in which my client first went to the city to apply, and it turns out it was in November. So this morning, I had my client go to the city again and request an inspection date.
Objection.
May I finish?
Hold on.
Please don't yell at me.
Excuse me. I expect that the attorneys are going to address each other respectfully and not yelling at each other.
I would like to finish my
So there's really not
statement.
anything to object to at this point, counsel. I'm just listening to what Mr. Dagger has to say.
I didn't get that.
This is the second time that's happened, and Your Honor, I just want to finish
What's the
my
second
statement.
time that's happened?
That she's objected in the
Okay, and
middle
I
of
just
sentence.
addressed it, so please continue.
Thank you.
Your client went to the city this morning.
My client went to the city this morning. My client was able to obtain, pardon me, Your Honor, there's a potential witness in the courtroom here who I think is going to be called. And what is your name? I'd like to identify
No,
who she is.
counsel, I'll find that out.
All right.
I'll find that out. Scott, can you go find out who? Actually, okay, Ms. DeClala, who is this individual?
I don't know. I haven't seen the video. I don't know.
Yeah, counsel, I'm just asking, who's the woman that's here in the courtroom?
Oh, this is someone who's assisting me.
She's assisting you?
Yes.
So she's not going to be a potential witness
No,
or anything?
no.
Okay, and what is your name, ma'am?
Ariel. I'm a friend of
She's a friend.
Collins.
Okay, you're a friend of Ms. Collins, but you're not intending
No.
to testify?
No.
And so she's helping you out, counsel?
Yeah.
Does she work for you, or she's?
No, she's. Yeah, and also
I'm sorry,
I
what?
filling her in on any facts that she might need because Ms. Collins isn't here.
What?
Okay, well, Ariel, if she's called to testify, won't be allowed to testify then.
I'm not calling her.
No, I understand that. I'm saying in the future or otherwise, because she's been inside here, so, okay.
All right, continuing on, Your Honor. As I was saying, my client this morning went to the city and was able to obtain an appointment for next Wednesday between 9 and 2 to conduct all the necessary inspections for the compliance certificate. What I'd like the court to do, if we're going to adjourn this matter, is that I would like an order of the court allowing all necessary inspections to be conducted by the city next Wednesday between 9 and 2 as regularly scheduled. We have no specific control over the exact nature. Now, Sister Counsel had mentioned that there's a statute.
Hold on, before we get to that,
Yes.
we're going to address this.
Mhm.
All right, counsel, I'm not addressing, C of O, no C of O, or collecting rent at this point. I'm just asking, is there an objection to the city on February 25th between the hours of 9 and 2 p.m. to go to the home to inspect the property?
Yes, because they have to get in contact with my client first. In fact, I have from the city of Wyandotte enforcement details. She submitted to them a copy of her lease. They were requiring that first. And under city ordinance, unfortunately, I don't have the point, but they have to get in contact with her directly. The city does. I would love to agree to that.
I don't understand what you just said. Do you, Your
The
Honor?
city has to get in contact with Ms. Collins?
Yes.
That's just not true, Your Honor.
Counsel, give me an opportunity, please,
Thank you.
without interrupting.
So this is from the SNA Online, and there's a summary here. There was a complaint, possible rental at the address. The tenant dropped off a copy of the lease and info for request. So now opposing counsel has scheduled the inspection.
Well, no, it doesn't sound as though he scheduled it. It sounds as though the city told Mr. Branson when they would be there for the inspection.
Excuse me for misspeaking. It's my impression they have to contact my client in order to schedule it.
And, okay, your state, is there something in the ordinance specifically that says that the tenant has to be present or the homeowner has to be present?
I'm not sure, Your Honor.
May I read the statute, Your Honor?
Okay. You have the ordinance there?
No, Judge, I'm reading the statute she cited to me outside.
No, I'm not talking about.
Well, there is no such ordinance.
Well.
There is no such ordinance.
Hold on. Counsel, Mr. Klala, I'm sorry. You stated that your client is required, that the city has to notify your client.
Yes.
Okay, where is that authority?
I'm not sure.
Okay, but you made that statement, so.
I did, yes. There is a statute, that's a state statute. However, I'm not sure the ordinance is. Again, what I was saying before was coming from BSNA online. But under MCL 125.526, that took effect in February of 2018. It was actually narrowing what could occur during municipal rental inspections. And those are actually exceptions. So they can't go in if it's vacant, they can't go in if it's responding to a tenant complaint, or if the municipal inspector has a warrant for the inspection. So my tenant did complain. This is an inspection that's being scheduled by the plaintiff, which is perfectly acceptable in my eyes, but I don't want to violate the fact that she's due notice under this statute.
Okay, just one moment here.
She's citing.
Hold on, counsel, just one moment. I pulled up 125.526, so please pull it up.
Direct your attention to paragraph 7 here. It's actually paragraph 7.
Hold on, counsel, just one moment. Except as provided in subsection 7 to 9 and 11, an inspector or team of inspectors must request and receive consent from the lessee to enter before entering a leasehold regulated by this act to undertake an inspection. So we'll read 7, 8, 9, and 11. 7, the owner of a leasehold shall notify the lessee of the enforcing agency's request to inspect a leasehold, shall make a good faith effort to obtain the lessee's consent for an inspection, and if the owner obtains the lessee's consent for an inspection, shall arrange for the inspection by the enforcing agency. 8, the owner of a leasehold shall provide the enforcing agency access to the leasehold for an inspection during reasonable hours if any of the following apply. A, the lease authorizes an enforcing agency inspector to enter the leasehold for an inspection. B, the lessee has made a complaint to the enforcing agency. C, the leasehold is vacant. D, the enforcing agency serves an administrative warrant ordering the owner to provide access. E, the lessee is consented to an inspection, or subsection C. If a lessee is not present during the inspection, the enforcing agency may rely on the owner's representation to the enforcing agency that the lessee has consented to the enforcing agency's inspection. So it doesn't appear as though any of these apply. I don't have a copy of the lease that would indicate whether or not the lease authorizes an enforcing agency or the city of Wyandotte inspector to enter the leasehold for an inspection. However, the lessee has made a complaint to the enforcing agency. So that seems to trigger the owner being permitted to provide the enforcing agency access to the leasehold.
That's correct.
That would be 8B.
That's correct.
And then let's see, 9 is the lessee shall provide the enforcing agency access to the leasehold for an inspection during reasonable hours if any of the following apply. And then it's 4 of the previous 5 as well. And then 11, before entering a leasehold regulated by this act, the owner of the leasehold shall request and obtain permission to enter leasehold. However, in the case of an emergency, including but not limited to fire, flood, or other threat of serious injury or death, the owner may enter anytime. So it appears, counsel, that under MCL 125.526, 8B Mr. Branson has authority to allow access to the home during reasonable hours. And 9 a.m. to 2 p.m. seems as though those are reasonable hours.
Thank you for the clarification.
Yes.
Are you recording, ma'am? Your Honor, I think
Hold on, ma'am, are you recording these proceedings?
No.
Okay, where's your phone?
It's turned off.
Okay, please present it over here for a moment.
Uh-oh.
Okay, here's what I'm gonna ask you to do. I'm sorry, no, hold on, Dave, I'm sorry. Can you please, enter your passcode? You don't have to show your passcode to the court officer, but put it in a spot just so that you're only entering your passcode and nothing else, please.
I have to turn on it first.
It's completely off?
Correct.
Okay. All right, I'm just gonna, so it's completely off?
Correct.
Okay, please hand it to the court officer for a moment. We'll leave it up this way. You'll get it back you'll get it back when we're done.
Oh, wait a minute, no, you can't take my phone from me,
Yeah.
because you're not authorized to take my phone from me.
Yeah.
I'm not valid like you give me rules.
Yeah.
I would like my phone back.
Yeah, all I'm doing is just making sure these proceedings are not being recorded.
Correct, and they're not, I have not recorded them.
Yeah, I'm just indicating it's gonna be here for just a couple moments, and then you're gonna get it back. I'm not saying it's for hours, no, as soon as we're done with this, you're
Oh,
gonna
no,
get
I
it
want my
back.
phone back. The court is not authorized to take my phone.
Yeah,
Under what basis?
because there has been previous recordings.
Not by me.
Can you please not interrupt the court? By Ms. Collins, there is a concern that the proceedings are being recorded. So I'm just trying to alleviate any of the concerns, and it's just going to temporarily stay right here. That's all I'm saying.
Can you please, under what law that gives the court?
Under the judicial discretion that's given to the courts under the court rule that allows phones to be brought into the courts.
There you go. There's your
That you
answer.
can take my property?
The court has judicial discretion as to whether or not to allow individuals to keep their phones. If you want to go put it out into your car, you can certainly go do that. It's just not going to be in the courtroom. So can you give her back her phone? You can go put it out into your car.
So because I'm friends with Ms. Collins, you're concerned that I will be recording?
No, ma'am, it's not because you're friends with Ms. Collins. There was a concern raised that there's potentially recording. You stated that your phone is off.
It is off, so
Okay.
how could have I been recording I looked up here, my phone
Ma'am,
is shut off.
Ma'am, this court has judicial discretion to ensure that there isn't anything improper occurring regarding any recording.
Correct,
Okay?
and it isn't.
Ma'am, it has been raised. So all I'm doing for purposes of the proceedings is for you to go take the phone out to your vehicle. I'm not arguing with you any further. I've explained the court's position. You can go out to your vehicle.
I will take it out from you.
Okay?
Stomp, 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 stomp. Bailiff's just gonna follow. Just make sure that happens. Just keep an eye on her. Make sure she goes back to the car.
Pursuant to MCL 125.526, 8B, the inspection is scheduled for February 25th from 9 a.m. to 2 p.m.
I'm sorry, it's 26, Your Honor.
You said the 25th.
My mistake, I misread it, it's the 26th.
26th.
26, correct, 226.
Okay, which I believe your client does not work on Wednesdays. I recall from last week. I think she.
Thank you for that consideration.
Tuesdays.
You may be more aware than I am.
I could be wrong, because I got the time wrong this morning when I sent the
Yeah.
letter, but I'm pretty sure that she works on the weekends and then on Tuesdays.
And I appreciate your patience.
Yeah, no problem. So, February 26th and from 9 a.m. to 2 p.m. Counsel, when are you back in town?
Judge, I couldn't schedule with my kids, so I'm not going to.
What?
I couldn't schedule with my kids.
What does that mean?
Like, one daughter is finishing Northwestern Law School, she couldn't take the time off to go, so I canceled it. I'm not going out of town anymore.
Oh, okay.
I don't want to go without my kids, so I can't.
I was going to have everybody come back, well,
Oh,
I prefer for everybody to come back Friday, because,
bailiff's back.
the inspection itself, I'm not saying it's a moot point, because obviously the property has to be inspected. But for these purposes, I don't know that that has a bearing one way or the other with what this court's ruling regarding the escrowed money. Because I believe that the issue that we have left to address is, where does the escrowed money get released to whom does it get released? And Ms. Collins raised a concern regarding overpayment of the utilities. And so there's that issue. So counsel, when the two of you were out in the lobby waiting for the court to call the case, did you go over any of the utilities?
No.
No, Your Honor. Well, we can try to address it before the hearing on Friday.
Okay. I mean, since you're here, you might as well, while you're out in the lobby,
we can
maybe look at it, or you can
But
maybe
the
go
problem
over
is,
to the offices.
Ms. Collins isn't here, and because she's not here, I haven't been able to get anything directly answered. So I don't know how constructive it would be.
Well, counsel, were you provided any utility bills?
I was. I might need a moment, and I might have to do it over the phone because there is some aggression outside in the hallway, and I'm not comfortable.
What?
I'm sorry, aggression?
Yes. I don't know how much I'm allowed to disclose because it's settlement negotiations.
I'm sorry.
All right, your aggression by?
Opposing counsel.
Okay, verbally?
Physically.
Oh my Lord.
Okay, what specifically?
He was stepping, the woman, Lily, who just left the courtroom, even if she shouldn't be involved in the conversation, I respect this, but he was physically stepping in front of her and pushing her back. I witnessed it.
That's not true, Your Honor. That's a false statement. That is a false statement, Your Honor. We were having a private conversation. This young woman comes up and starts interrupting, getting into my face. So I turned my back, not wanting to confront her, because I didn't want to deal with it. You can see why from earlier what happened. I just don't want to deal with it. It's me and her. She's a very kind human being. I don't see any reason why anybody else can be involved.
Referencing Mr. Klala.
I am.
For the record.
Yeah, we've talked on the phone. She's a tenant in the building I built. The guy she works with is my childhood friend.
It's not
Scott.
relevant.
It is very relevant. Finish,
No,
please. Man, they're just producing issues for no reason at all. I'm willing to have any conversation with anyone, particularly Ms. Dakala, because I view her as a very kind human being. And I'm not sure where this hostility is coming from, other than the distraction for further noise.
Okay.
And that's something that I'm trying to avoid.
Here's what I'm going to say. So, Miss Ariel or Miss Lily, I'm not sure what her name is. I thought she
Ariel, I'm sorry, Ariel.
Oh, okay. She really has no point really in participating in the conversation between you and counsel. But what I'm going to say is we have a court officer that can be near the both of you if, for some more, so that you can feel a bit more comfortable.
Okay.
So we can do that. Because I do think it's imperative that as much as it can occur for counsel to be in the same room showing the paperwork that's there to be shown on both sides, as opposed to, getting an email or talking on the phone or something like that. So if there was a court officer that's there, would you feel more comfortable with that?
A little bit, but frankly, opposing counsel is a fantastic order, but I'm shaken up. I'm shaken up, and I'm not trying to cause a distraction. I can't deal with an overly aggressive person outside of the courtroom, even if it's, when people aren't looking. If it's over the phone, fine. If it's words, fine. I know that Miss Ariel is not my technical assistant. I know that she's not technically involved in any aspect of this case as a party.
Right.
But I don't feel well internally. That's the problem.
A sick day or?
And I need to go forward on this motion this amended motion to dismiss, but I can't tell my client that she can't be here, can't participate. If she's insisting on being here, I have to respect that.
I didn't say she couldn't be here.
Right, and I know you didn't. But what I'm saying is that, to me, it's very clear what the situation is, and that if there's an eviction action, it needs to be done differently.
It's very clear.
Yes, I'm not gonna get into the substance of the matter of the amended motion to dismiss.
Oh, please do.
Okay.
Please do.
I don't know what she's,
Well,
I
okay.
don't understand what's going on here.
So
And I,
everybody can be back Friday?
Yes.
yeah.
What time?
Your Honor, there's just one issue.
Hold on, let me, well, okay, does the issue affect Friday?
It does. Let me tell you why. If the court decides to see the video, we were told by the court clerk that we can't bring with us a stick that you can plug in. But what we've done instead is that we put it into a Dropbox. And I'm hoping, and I brought my assistant Ashley because she's a lot more sophisticated with technology than I am. And so the only reason I've asked for her to be here is to facilitate showing the video if you decide to see it on the screen or multiple screens, however the system works. So that's about the only technical issue that I'm concerned with. I don't know how to do that, Judge. But if you know how to do it.
Your assistant can't be here on Friday?
No, Your Honor, she's going to Florida.
Okay, well, it's just about just make sure she has it saved on your desktop, and that way, when you do your screen sharing, you can access it and pull it on up.
Well, I was going to ask the court, since we emailed it in a Dropbox to you, would you be able to do it yourself here?
That's not what we do, and I'll tell you why. Number one, and even though it may have come from the police department through the records, it's a way to make sure that we're not getting any viruses into our equipment. So, no, I'm not going to play it on my device.
She's just suggested an idea, if I may.
What's that?
She can appear by Zoom if it's possible, and perhaps we can do a screen sharing, and then it can be demonstrated on screen through screen sharing. Is that possible to do?
Yeah, that's fine. I mean, the sole purpose for your assistant is to play the video, correct?
That's right. That's correct.
Okay.
I don't know how to do it, Judge. And in other courts, in circuit courts, we pre-arrange it. So what happens is that some sort of a cord is plugged from from the computer to the screen, and it plays on the screen. That's how we've done all the other video. But, when I started.
I don't think there's a cord long enough for, I don't know.
When I started college, Judge, I swear to God, they weren't getting any computers, they were using cards. By the time I graduated, we got into the PC. So I'm not technically savvy. But at the end of the day, Judge.
Change with the times, Mr. Dagger.
Judge, I'm retiring next year. I'm almost 60. I don't really care. And I'm going back to the farm in South Lebanon and raise chickens. Think I'm kidding? It's true. I'm not joking. My grandfather lived to 95.
Chickens.
I'm sorry, can we limit the extra comments?
So,
Your Honor, with all due respect, counsel here has demonstrated a great deal of agitation to me, and now I'm in fear.
Oh, great.
What are you in fear of, Mr. Dagger?
I'm in fear of being anywhere near counsel and being accused of something. So, I'm just letting you know on the record what I'm now fearing.
We each need mediators, and they need mediators.
I'm sorry that I'm a man and that I am who I am.
Gender has nothing to do with that.
But that's what she was suggesting, Your Honor.
No.
The chicken farmer is now a nervous chicken farmer.
Anyway, Judge, we'll be back on Friday. What time is that?
May I request that it's at 8:30?
Let me just double check what the docket is.
Okay.
I'm here all day. I don't have anything I'm presenting. So let me check what the docket is.
We're okay for 8:30 now.
Well, I mean, we'll do 8:30.
Mrs.
There may
Ari
have
is
to be
taking
some
up the channel
interruptions
right
where I have to move
now.
people in and out of breakout rooms and such. But we'll do 8:30. Everybody can be here at 8:30?
Your Honor, is there a Zoom login information that we can get now?
Yes, just one moment. Well, let me just confirm. I know I just said that there's, okay. So, 8:30 a.m. I'm going to ask that you both email me the briefs that were submitted via my file. just so I can have those to review in the event. I'm not sure when Ms. Perry-Askew is returning. So please email those to review. Please email to me the amended motion to dismiss and your response, Mr. Dagger, plus the video.
Your Honor, I actually did attach the amended motion to dismiss as an exhibit to my brief. Do you want me to do it differently, or is that sufficient?
Did you draft the amended motion to dismiss?
No.
Okay. No, that's fine. That's fine. It can just stay the way it is. Mr. Dagger, though, I need the response. If you can email the response and just remove the video from the attachment.
We'll do that, Judge.
I'm sorry?
We'll do that, Judge. You also wanted the memos, I assume, Your Honor? You asked us to brief?
Yes, so that's what I did. I asked both of you to email the briefs that you submitted.
What's the email address?
This may be spicy, but legitimately, I don't know what they're talking about.
27dc@wyan.mi.gov.
You should already be copied on an email from me to that email address.
And then the Zoom ID is 656-647-7075.
Is there a password, Your Honor? No password, okay. Can I repeat that to you, Judge, just to be clear? 27dc@WANDOTTE.
Wait, W what?
WAWYO, is it YAN? Sorry, WYANDOTTMI.
There's an E at the end of the.
Oh dear.
TTEMI.gov, correct?
WYANDOTTEMI.gov.
Got it, you got it. And the Zoom is 656-647-0775, correct?
No, 707.
Okay, she's got it. She's the one that needs it, so, okay.
Oh my gosh.
All right, and if you have any questions on that, it's on our website as well.
All right.
Okay.
Thanks again for all your patience.
So Judge, in terms of the inspection, it's not going to be in written form. Do you want us to submit it to you? We can do it now if you want.
Submit what? The
order of inspection. We can prepare relatively quickly and submit the signature. So that.
Oh, you can bring it on Friday. That's fine because it's still before Tuesday.
Yes, ma'am. We'll do that.
Okay.
All right.
All right. Anything else?
No.
Okay.
Thank you, Judge.
As Scott walked out of the door, he said, "You're going to have to unmute yourself." I'm like,
I'm not talking.
it doesn't look muted. I don't know. Are the lawyers fighting with each other?
Yeah.
Hold on, let me go back on the record.
Okay. What we can do, Judge, with regards to utilities, I can have my assistant talk to her directly, or we can exchange emails. I won't be part of the conversation. I don't want to be physically in any place near her. So I'm offering her an opportunity to suggest she can talk to my assistant, Ashley, or we can go back and forth in email. I'm not quite sure what would be more efficient.
Well,
In 32 years of practicing law.
I'm not going to get into getting into all the dissertation. Do you want to speak to Ashley?
I would speak to anyone. I just, I mentioned he's being physically aggressive and now it's being pushed over onto me somehow.
Who's pushing over onto you? The court's not pushing over.
I just was mentioning, no, not the court, opposing counsel. I was just mentioning I can't talk to him outside right now. I need a second to breathe.
I don't want to.
That's all.
Please, hold on. What about speaking with Ashley? And the two of you can go over the utilities and kind of see where you're at. And then Ashley can get her steps in, go back and forth with Mr. Dagger, somewhere where he's somewhere else, and the two of you can have a conversation, you meaning you and Ashley.
Court-appointed mediator.
Conversation regarding the utilities.
I have a panic disorder.
Okay.
Do you have chickens though?
Yes, I can go sit with Ashley.
Okay. All right. So, Ashley.
I'm going to stay here.
I'm familiar with everything in the case and I would also heard this.
Okay, and then if there's any
questions,
whatever, I'm gonna have you go back and forth with Mr. Dagger.
Yes.
But if the two of you have to have a conversation, then I'm gonna have the two of you, have that conversation outside the presence of, Ms. Teklala and Mr. Dagger. I'm gonna have you, cause I have some other matters that I'm handling here. So if you have to have a conversation, then you have to step outside.
What I'll do is I'll sit next to the court officer, Your Honor, near the entrance, and I'll sit there and go back and forth.
That's fine.
I'm not interrupting your court.
We can open up the, either the defense attorney room or the prosecutor room, so two of you have a desk. Okay, thank you. Okay, thank you. We'll see you both on, we'll see you all on Friday. All right, thank you.
Yay, Friday. Guess we need to be here for that, too.
Yeah, okay. And Mr. Dagger, when they're discussing, whatever they're discussing, please do not make any comments, okay? At all. Don't make any comments or anything. I'm not suggesting that you will. I'm just.
Just saying.
Judge, I'm a father of 2 girls,
Counsel.
and you have no idea how upset I am.
Counsel, I want everything to go as smoothly as it possibly can, okay?
I think you know how I feel.
Thank you.
Thank you.
Okay.
Thank you.
All right. So on.
She's rubbing her temples. Look at the judge. She's like, there's not enough Advil in this state. Oh, my goodness. That's funny. Josh, that was funny. We missed the first one. Mike got it. Lawyer, you know. No, that's Peter Trago's the lawyer, you know. Attorney Mike from Chicago. Law Talk with Mike got the first one. I'm going to go ahead and stop this. And I wanted, we saved the moment that the jury got released today because that's the one thing we got to see. So let me see if I can bring that in for you as well right now. Give me just 1 second. We'll play that on 3. This happened earlier, about 45 minutes ago, roughly. Half an hour because of the delay and 15 minutes because of what we were watching.
Okay, ladies and gentlemen, today has been a little bit of an unusual day. Just
you can say that again.
A lot of legal issues that I've had to go over with counsel, and I am grateful for your patience. As I've stated on numerous occasions, I thank you all for your service on behalf of the state of South Carolina. I thank you in Greenville County. I'm going to allow y'all to break for the day. I'm going to ask that you come back at 9:30 in the morning, consistent with my admonition to you all. Again, you are prohibited from watching any type of TV coverage of this trial. Do not do any research on anyone involved in this case. You're not to look at any social media. It's important to this trial, justice and fairness to the defendant and the state, that you only consider the evidence that comes in through this courtroom, and you're not to discuss this case among yourselves. Begin deliberating until I tell you to do so. And lastly, if anyone approaches you to talk to you or ask you anything about this case, you need to immediately let me know, okay? I will see y'all at 9:30 in the morning. Thank you again.
So that was the jury getting let go, and then we get nothing after that. So, so that happened, and we'll see tomorrow. Are you good? I hope so. Okay. We're all done with that one. All right. Josh, thank you very much. Josh deserves a raise. Double the pay today only. Let's see. That was a little hot. So today was more or less a wash. Brittany, yeah, we're going to rinse, wash, and repeat. We're going to try again tomorrow and see if we can get a little further. We need to set up a fund for Josh. Donate for Josh. I don't know how to do that. I'll have to talk to Brandy. How do we set up? It would have to be separate from me. Otherwise, all the money just gets eaten up by YouTube and tax money. How do we set up a fund for the mods? You know, so they can like go to Cancun and things like that and be a mod from the beach. PayPal, yeah. Yeah, the mods need to build their own buy me a coffee. But even that gets crazy. Go fund mods. It's better than only mods, which was an idea that was floated earlier, but which is different. All right. Amazon wish list. Oh, that's a great idea. Have the mods make an Amazon wish list and we can share it. Yes, for the mods. Now everyone wants to be a mod. Amber's like, look, I've got Venmo, Cash App, Apple Pay, PayPal. That's all I got. We'll see if we can figure something out. I owe them my undying thanks. We've given out some awards, some custom awards to them previously, and we'll continue to be very, very thankful for amazing mods. I can give them a reflective sticker. I've got 7 extra, says Katie Bug. You bought a pack. Judge Boyd came on. Josh says I've got all the things too. I also take certified checks. You know, in a pinch, Josh, I would accept an armored truck delivery if it needed to be that. I mean, I will bend over backwards. I'm just kidding. Samantha, thank you very much. Amazing. You have the original sticker, nobody else does. You do, Amber. I did give you that one. It is one of a kind. Just make sure it's a full armored truck. It'll be riding low. It'll be riding low if you watch the what game is that? I forget the movie. But all right, where are we at? We can go to Judge Boyd, who we have not been in quite a while. We've got nothing else this afternoon because the court released the jury this afternoon. Let's see. That's Judge Raquel. Hang on one second. Okay. You can hear my kid practicing the piano in the other room.
To 6 weeks. So, which do you prefer?
Seems like forever since we've been here.
I can't do the 3 years TDC.
No, 4 years TDC, or these are your two choices: 4 years TDC, or I will follow everyone's agreement and recommendation for probation that you go into inpatient treatment. The wait time for inpatient treatment is 4 to 6 weeks. Now, this is what I can tell you. Regardless of what happens, whether you're waiting 4 to 6 weeks to go into treatment or whether I sentence you to 4 years prison, time is going to pass. It just depends on what you want to do with that passage of time. Do you want your passage of time where you're just going to prison? Or do you want your passage of time to mean something more? You're getting clean and sober. And here's the thing. You know yourself better than I know you, better than your attorney knows you, or better than the state or probation. This is a choice you have to make for yourself. So whatever you want to do, I'm not going to look at you any differently. You know what I'm going to end up telling you? If you choose to go to prison, you know what I'm going to tell you? When you're released, if you can't find a place to help you maintain your sobriety, you come back here, I'll find a place for you. If you decide to take treatment, guess what I'm going to tell you? If anything happens, let probation know. If you feel they're not addressing it, you can still come back here. So those are your two choices. There are no other choices on the table. There's no 3 years on the table. Okay. All right. The court is finding violation of condition number 4 true. The court will deny the motion. Alternate amend conditions. And these are to happen in custody. So there's to be a referral to felony drug court. And also, she's already been approved for SATF. All right. So in custody, there's a referral to felony drug court. If she is not accepted in the felony drug court, there's to be SATF, and there's also to be TAP evaluation in custody. And let me see one other thing. And is there a need to extend her or no?
No, Judge.
All right. Is there anything else you need from the court to be successful?
Thank you.
All right. So off the
Communication is
record,
key.
this is what you're going to be waiting for. You're going to be in custody. Somebody from probation is going to come visit you. They're going to give you a TAP evaluation. TAP evaluation is to figure out what your drug history is. Be honest, because you want to successfully complete this.
Yes.
Then the other evaluation you're going to wait for is felony drug court. Felony drug court is a great program. It's an intensive program, but they'll be able to help you.
Okay.
If you're not eligible or they deem you not suitable for their program, then it's going to be SATF. You understand?
Yes, I understand.
Any questions about anything?
No, thank you. I do have a question. I'm sorry. I just lost my brother on January 29th while I was incarcerated. I just want to know, is there any way that they could help me at least attend the services?
You'll have to speak with probation concerning that.
Okay.
And you know what? Let felony drug court know that. All right. When is his services?
Oh, well, right now they still have the body because he was murdered. So his body's still being held at so under investigation, I'm guessing. That's what my mom told me. But so that's all I know right now, that his body's being held. So they haven't pursued yet with dates.
Well, I will tell you what, if you will let probation know when it comes up, I'll see what I can do.
Thank you.
And I'm sorry for your loss.
Thank you.
All right. You're welcome.
Now have a seat. Get on this side.
All right, counsel, you're excused.
Thank you, Judge. Have a good day.
All right, you too.
All right, let's see.
Oh, no, he's here. Oh, he's here.
Yeah, thank you.
He did. Yeah, he's right back. Yeah, he did. If you get it
I supposedly have a new option on my chat, but I can't see it.
I'll see Phyllis is out there too. Can you interpret it down to the community center for sentencing? Thank you.
Oh, it gave me goals? No, that's not it. I can set timer. Oh, the timer's for just the goal. Can you imagine Judge Boyd dealing with that swingers case? Which didn't really end up being swingers today. It was more about just, I'm triggered, I can't be around the other person, I need a mediator. Trying to find out where my special chat is.
Kevin Jones?
Yes. Oh, that's not me. Sorry, Judge.
Yes.
This is an off docket matter.
Okay.
Mr. Jones has come to the court with some concerns. He's on GPS monitor, and he would like to see about getting his
to not be
monitor times adjusted.
All right. So what times are you requesting?
Well, for right now, I have a newborn child.
Okay. Congratulations.
Yes, ma'am.
Let's make sure we are giving them the best example that we can. All right.
So I was supposed to be at the hospital at, I didn't think I was going to be here this long, but at 2:30, I have to, the baby is ready to be discharged.
Okay.
And I have to be there. They don't want me to come in and out from the baby feeding this day, that day. They're going to do it all in several hours.
All right. Any objections to him with the baby at the hospital?
No, Judge, I think there's just other stuff that might be needs to be addressed, and I'll let him explain it.
Okay. So there's no objections to you being at the hospital. Are they still waiting to release the baby, or have they already left?
No, I need that to do the baby feeding and the CPR class.
Oh, you got to do the CPR classes.
Yes, ma'am.
You know, back in the day, they didn't give you CPR classes. They just said, good luck to you and your baby. Yeah. All right.
I'm a full-time student at a South Texas Vocational Technical Institute.
Okay.
I go to school from 8 a.m. to 1 p.m.
8 a.m. to 1 p.m. That's school.
I'm currently looking for a job.
All right, so 8 a.m. to 1 p.m. school. What days?
Monday through Friday.
Monday through Friday, okay? And then you have the baby hospital. So there's going to be no issues with you at the hospital, okay? And there's no issues with school. I think everybody wants you to better yourself. All right, so what's the other issue?
So maybe besides setting up appointments for the baby, looking for a job, there's nothing else really.
All right, so State, let me ask you, is this something maybe tracking with curfew?
Well, Judge, I think, I don't know if it's been said, but my understanding is that the mother of the child is not present.
Mm-hmm.
And that's a concern, because I don't know who's taking care of the child when she's not around and he's not around.
Okay.
So that's just.
The child's in the hospital right now by themselves?
All right, who's taking care of the baby when you're not around? I'm sorry? Oh, isn't it always grandmothers being parents? All right. So he's saying his mom. Any other concerns?
Not necessarily, Judge. I just to let the court know, I did email the school for the state connected accommodation welding classes that confirmed that he was attending from Monday through Friday, 8 a.m. to 1 p.m.
Okay.
That's what the coordinator said. And the only concerns are just to make sure that the newborn child is taken care of. That's the other concern of the state.
All right, let me ask you this with regards to the newborn. So when you're not around and the mother is not around, you say that your mom is the person who takes care of the child? All right.
Yeah, so
Wait a minute, you're just about to say something important and the machine is printing. Okay, yes.
Daycare services, if it's needed.
All right, please check into daycare services. Just don't take your baby to anybody's daycare. You know, people need to start investigating daycares when you're taking your child there. I always would tell clients that I would have, would you just go to a strange house, not knowing anybody, and you just are in there, or would you want to investigate what's going on? So make sure that you investigate the daycare, because your baby is not at the age, I believe, where they can talk and tell you what's going on, right? So investigate. Just don't drop your child off someplace, okay? All righty. So is there an issue with tracking, or do y'all want to, what I can do is I can try out this schedule allowing him to go to school full time, be with his child and see how that goes, and then maybe move towards tracking only.
Judge, yeah, I mean, the state's be okay with it. It seems like he at least is trying to excel and going to school and being a responsible father. The concern was that the mother wasn't, I guess, present or not able to be present because of the possibility of incarcerations. And so that was this concern of the state, and this was brought to my attention from probation.
All right, so let me ask you this. Have you had a chance to talk to his mom?
She said she apologized. She was looking for parking. She didn't tell me.
Oh, she's driving around?
She's here?
She's trying to find parking.
Oh, let me ask you, can she zoom in? Does she know how to zoom?
Probably driving.
Share the link with all of us.
Share
the link with us, Judge.
Judge, and I did tell the state that in regards to his concerns, there are field visits that are already a part of his condition terms to where our officers will be doing home visits.
Okay, and then what I can say, and as a part of the conditions that I added, was that he's to reside with his mom. So you're residing with your mom?
Yes.
So, all right then. Do you want to do tracking only, and then we can do an update?
That'd be fine.
All right, so what I'm going to do is I'm going to do tracking only. What that means is Really? Don't go wild, right? Just do your school, taking care of your child, looking for employment. Don't get sidetracked because it's easy to get off that path, okay?
Even before I got it put on Friday, I've been at home and just going to school. I ain't been trying to get no trouble. No.
All right. Well, I'm so proud that you're actually bettering yourself. Welding is a good profession. Don't burn yourself too much.
Literally.
Well, you know what they say? They say you're not a welder until you're burned. And then I knew an attorney who decided he was going to be a carpenter. He's a carpenter, but he lost a digit. And he said, people say you're not a carpenter until you've lost a digit. As people say, you're not an attorney till you've had a grievance filed against you. There's so many professions like that. All right. So what I'm going to do is I'm going to do tracking only. And does he have community service hours?
I do.
All right. So, Bashan,
Yes, Judge.
he has the community service hours, but I did put down he completes parenting classes and his community service hours will be deemed satisfied. So do the CPR classes, do parenting classes, and then you won't have to do the community service hours. All right, so they'll be tracking only, and then we will recall this for, you all want to recall this in 30 days or 60 days to see how things are going?
Either. We'll report the court.
All right. Norma,
Yes, sir.
we're going to recall this. It's 2023 CR 5280. We'll recall this.
Josh, I got to wait on
What's
that
a
one.
good time for you to come down?
I can't do that one yet.
What day of the week? Okay. So any day in the afternoon, we could set it at 2. You get out one. You want to do 2:30?
Yes.
All right. And then I understand if you're driving from school. So we can set at April 7th, 8th, or 10th. So that's Monday, Tuesday, or Thursday. All right. You want,
I ain't got no specific day.
all right. So we'll do Tuesday then. No, usually that's our jury trial date. We'll do it Monday, the 7th. Okay. And I'll put you down April 7th at 2 p.m. I'm saying 2 p.m., but I'll write on the docket sheet 2-ish because sometimes traffic is some kind of way. Well, congratulations. I'm glad you're doing well. Keep it up, okay? All right, thank you. Yes, Norma, can you give him a reset form and put 2-ish on there, please?
Okay.
Two-ish.
You said 2:30, Judge?
Yeah, well, 2-ish. So you can put it down for 2 and I'll understand if he's a little late.
All right. By the way, Mrs.
And
Arby,
Kevin, Mr. Jones, make sure you call the hospital to tell them that you're on your way.
everyone wants you instead
Okay.
of me. I'm serious. They're like, boo, bring back Mrs. R.A. All right. We are 20 likes away from 1,000. From 1,000. Sorry. 19 now. Nine left. There's 9 of you out
All
there.
right, good. Deputy, could one of you make the announcement for Jose Ricardo Maciel?
Jose?
Text message on that?
I can't do this. I need to do my shoulder
Yes.
over the radio. We hit it. We hit 1K. Thank you very much, everybody. That's our sort of goal every day. All right, let me pause for a minute. We're gonna bail for just a minute and let me tell you something. Sorry, I had to run out and take pictures of the damaged part that came in for our shower. And they're going to send us another one. We're going to try again and see if the next one is not broken. So, anyway, that's it. We have court today in the trial that we're following with Zach. It was spicy, but most of it happened off camera. So you sort of got to watch and read between the lines to hear what happened. Today, the defense took over. They gave their opening statement. They presented to the judge the idea that they were going to use a in defense of others defense, meaning I killed her in defense of others, speaking for Zach. The judge ruled that that was going to be very limited, extremely limited, like that you're not going to bring in the other and the why the other would need that. The jury has already heard from the defense lawyers that the defendant did it, and he has a good reason he's going to tell you, but now he can't tell you. So I don't know where we're going from here. The jury's been talked to for about 15 minutes today in the courtroom. The rest of the time they spent waiting, and now they've been dismissed for the rest of the day. They're going to come back again. They start at 9:30 in the morning, which means we won't see it until 10 with a half-hour delay on the live feed. And we don't know. Is Zach going to take the stand? Is he going to testify? Is he going to say something? Is he going to get up there and say, I did it for a good reason, and I wish I could tell you, but I can't? I don't know. So I wanted also to let you know, Christy called me. She wanted to talk off the air. There's a lot of information circling out there, and a lot of people in the community who are supporting Zach know the details of just what the images were and how bad it was. And she's heard things that she will never be able to forget as far as what was contained in these files. Really, really bad. Really, 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 really bad. And a lot of people are supporting Zach because of that he did the right thing, according to them. So we'll see how this ends up. The jury isn't allowed to know by the judge's rule, although it's sort of a lot like the Colin Griffith trial. I think they read between the lines and might exactly know what's going on. I mean, you can try to hide something for the jury, but we've been close enough to the issue that I think they know. Is the live going to be delayed tomorrow? It's been delayed every day. So yes, we've just been playing catch up. So it only affects us when we're not. I mean, when we are live, it's the only time it affects us. It's been delayed the whole time. The jury did not read between the lines, or maybe they did and just decided differently. I would say you misunderstood. Zach and Mello were not involved. Christine and Post allegedly were. Christine was the victim. Post is currently incarcerated pending trial. All right. Yeah, it's really bad. It's really, really, really bad. That's it. Anyway, she's going to be hopefully back in court tomorrow. Christy, one of our court watchers, will be back there. It's packed, so she's going to have to fight for space. And then as things go down, she'll be trying to call in. She was a little nervous because of what she wanted to talk about. She's like, I realize I can't say some of this stuff on the air. I did not want to know the details as well. So that solved it. I don't know. She just, from what she told me, it's really bad. How did they get a jury that didn't know anything about the case? You would be amazed. I imagine you could probably find some people who didn't know we landed on the moon. And you could also find some people who think that it was all staged. But there are people out there who just didn't pay attention when it happened. Do we know if the sister knew? She painted a wonderful picture about the deceased. I don't know. I don't know if she knew or not. Yeah. Fitz News goes into it. If you want information about that, they're probably one of the good ones to seek that out. So, Detective Fitz, wait, when did we land on the moon? All right, let me tell you where we're at. We're gonna wrap up the day. It is 4:30. We're only about an hour early, and the Earth is round. What? Okay, you've just blown my mind now. Barb, it hasn't been that bad. It hasn't been that bad, especially because we've been catching up and on delay. I've been able to run my delay system so I can see about 5 seconds into the future, and make a change in a moment's notice if needed. And we haven't had to do that, unlike the Collin Trail. We had to do that a little bit, or Megan Boswell. I forget which one it was. Could that go towards sentencing? The problem is the law in South Carolina doesn't allow for his version of I had to. That's his issue. He used to be a flat earther, but I soon came around. Barb, it's a lot of work, but I love what I do, and you guys make it a lot of fun to be here with y'all. So, anything else we need to cover today before we let everyone go home for the day? I'm going to keep working on this short that I've been working on way too much last night and try to get one. I do not know how to upload a short when I edit it on my computer. I can do it from my phone just fine, but how do I edit from my computer and upload that? Bedtime for me, says Myra. Myra, thanks for being here. I appreciate it. I'm still confused about a round Earth, and then we say to the ends of the Earth, the corners of the Earth. We kept the saying, but we changed our opinion of what it was like. To everybody who has, basically, if you're in the central United States east, and from there east, it's getting real cold real soon. Please stay safe. Tomorrow's going to be a crazy day. It's going to be snowing here all day. It's going to turn to an ice storm sometime after 12 hours or so. We're just not going to go anywhere. So if needed, we'll set up the Starlink and try to live stream from that, but I think we're going to be all right. Fingers crossed. Stay warm. Stay safe. Please don't do anything you don't have to in this bad weather. It's terrible out there. Not now, but it will be. Tonight when you go home, please hug the people you love. Smile at someone. Make their day just a little bit better. And please stay safe till we go live again tomorrow morning, where we hope to continue the defense's case in this Zach trial. We want to hear from Zach. He may take the stand. Or we might have more fireworks. We'll see what happens tomorrow. You guys have a great day. We'll see you in the morning. Bye-bye.
Because he's the guy.